drives real estate professionals crazy is when they list a property they believe is in the person they're talking to's name because there's a trust, and yet they come to find out the property is in a deceased person's name. Here's the example. And when I say trust administration today, let's call it the simplest, most general way to say trust administration. Let's say a husband and wife deed the property into the name of their trust. When the husband dies, for whatever reason, the wife takes the property into her name only. In other words, they file a death of trustee, an affidavit of death of trustee, which is all they needed to do to leave it in the trust and solidify that the wife was the person that could sign. But then she takes an additional act and signs a deed as the sole trustee to her name personally. And there you have it. You got a beautiful trust. It's written perfectly. You go to the Schedule A and it lists the property that it's in the trust. And you come to find out it's not in the trust because the wife had deeded it out of the trust into her name. So when she dies, that property now becomes a probatable asset. So this is something to be very conscious of. If a property is in a trust and it then is administered or it is dealt with after the death of one of the trustors or the trustor or a single trustor, where did it go next? Did it stay in the trust? No probate. Or did it go into an individual's name, and if that individual died, now we have a probatable situation. So keep an eye on those deeds. It's a common thing.